Hello and welcome to Law and Life. This is Shashank Mishra as a host here with Senior Advocate, Supreme Court of India, Sudh Markandeji. It has been recently suggested that apart from important constitutional and legal topics, this channel may also put out videos on ordinary day-to-day legal subject to interest to the common man. On this, my first question is what would be the scope of the subject on this topic?
So the scope of transfer of cases is wide and comprehensive. It covers civil as well as criminal cases. It is also across the entire range of courts, that is the Supreme Court, the High Courts, and the District Courts. Um, and of course, the transfer of cases uh, uh, in the courts junior to the district courts. So let us therefore divide the subject in three parts. Part one dealing with the transfer of matrimonial cases by the Supreme Court of India. Part two on the transfer of matrimonial cases by the High Court. And part three with regard to the transfer of matrimonial cases by the district courts.
So let us start with the civil transfer petition, which cases can be transferred.
In exercise of power under Section 25 of the Code of Civil Procedure 1908, the matrimonial cases of every description can be transferred, namely those relating to restitution of conjugal rights. It has now been deleted, judicial separation, divorce by various modes, custody and maintenance and education of a child under Section 26 of the Hindu Marriage Act. Uh, there is one particular case to which I will refer. In G. Vijayalakshmi versus G. Ramachandra, an old case, AIR 1981 SC 1143, the husband's plea to exclude matrimonial cases other than under sections 10 and 13 of the Hindu Marriage Act was rejected by the Supreme Court. It was held that the power under section 25 is very wide.
So please tell us about what Section 25 and Order 41 of the Supreme Court Rule 2014 provide for.
I may say that substantive provision of transfer petitions in matrimonial cases in the Supreme Court is section 25 of the Code of Civil Procedure, while the procedural part, insofar as the Supreme Court is concerned, is governed by Order 41 of the Supreme Court Rules 2013. Before the substitution of Section 25 in 1976, this power was very narrow. Firstly, it vested in the state government, and secondly, it could be exercised only in respect of suits tried by a single judge of the High Court. The rules made by different High Courts also aggravated the problem. In 1976, several sections of the Code of Civil Procedure, including Section 25, were amended. It was a comprehensive amending act. Now the power to transfer under Section 25 vests in the Supreme Court, and it has been enlarged by that amendment of 1976 to cover not only the original jurisdiction exercised by the single judge of the High Court, but all the cases, appeals, and other proceedings. So just mark the words all cases, appeals, and other proceedings to and from any other civil court. Now, Section 25 provides that on a motion on application of a party supported by affidavit, after notice to the other parties and after hearing such of the parties who desire to be heard, the Supreme Court may at any stage, mark the word, at any stage, if satisfied that an order under this section is expedient for the ends of justice, direct that any suit, appeal, or other proceeding may be transferred from one high court to another, or in one state to a high court or other civil court in another state. The court to which such suit, appeal, or proceeding is transferred shall, subject to any special directions in the order of transfer by the Supreme Court, either retry it or proceed from the stage at which it was transferred. If the application is dismissed, the Supreme Court is of the opinion that the application is frivolous or vexatious, it may order the applicant to compensate the person who opposed the application with a sum not exceeding 2,000 rupees. Now, the law applicable to any transferred suit, appeal, or other proceeding will be the law that governed that suit, appeal, or any other proceeding which was originally instituted. So let's take one example. Supposing the suit, appeal, or other proceeding was in a Delhi court and it was transferred to Allahabad, then the law which governed the suit in Delhi would apply. Now, coming to the provisions of Order 41 of the Supreme Court rules, in tune with Section 25 of the Code of Civil Procedure, Order 41 of the Supreme Court rules provides that the petition in writing under Section 25 shall be filed with the supporting affidavit, succinctly and clearly stating all the relevant facts and particulars of the case, the name of the High Court or other civil court in which the case is pending, and the grounds on which the transfer is sought. Such petition shall be posted for preliminary hearing and orders as to issue of notice. On preliminary hearing, if the Supreme Court is satisfied that prima facie case has been made out, it will issue notice to the parties to the case proposed to be transferred to show cause why the case should not be transferred. A copy of the order of the Supreme Court shall be transmitted to the concerned High Court. Lastly, service of notice shall be completed at least 4 weeks before the date of final hearing. Affidavits in opposition, that is in common parlance called the counter affidavit, must be filed at least 1 week before the date fixed for the final hearing. The affidavit in reply, that is in common parlance called rejoinder affidavit, shall be filed at least 2 days before the date of final hearing. Moreover, the registry of the Supreme Court will not accept any filing without the endorsement of service of affidavits on the parties concerned.
So can you kindly tell us, please, which matrimonial cases can be transferred to the criminal transfer petitions?
By criminal transfer petitions, all types of criminal matrimonial cases can be transferred. Like, let's say, cases under Section 125 of the Code of Criminal Procedure, 1973, for maintenance of wife and children. Cases under Section 498A, cruelty by husband and other relatives, and then the Dowry Prohibition Act. Then cases under Protection of Women from Domestic Violence Act, 2005, or even other cases.
Also, please tell us about Section 406 of CRPC and Order 39 of the Supreme Court Rule 2013.
Section 406 of the Code of Criminal Procedure 1973 is the substantive provision for the criminal transfer petitions. And Order 39 of the Supreme Court Rules 2013 deals with the procedure governing such transfer petitions in the Supreme Court. Section 406 has very wide scope, namely, whenever it is made to appear to the Supreme Court that an order thereunder is expedient in the interest of justice, it may direct that any particular case or appeal be transferred from one high court to another high court, or from one criminal court subordinate to one high court, another criminal court of equal or superior jurisdiction subordinate to another high court. So mark the words are very wide in scope and effect. The Supreme Court acts under Section 406 either on a motion by an application by the Attorney General of India or an interested party, except when it is moved by the Attorney General of India or an Advocate General of a state. Such application must be supported by an affidavit or affirmation. In an application under Section 406, uh, supposing it is dismissed and the Supreme Court is of the opinion that it is frivolous or vexatious, it can compensate the person who opposed the application for a sum not exceeding 1,000 rupees.
So, what are the uses ground of transfer?
Actually, grounds of transfer emerge from the peculiar facts of each case. Usually, grounds of transfer by wife are her indigence, her inability to travel long distances from the place of her abode to the place where the case has been instituted by the husband, her safety of her child, the clout and resources of the husband, her reasonable apprehension of not getting justice in the court where the court has been instituted. The husbands usually urge the lack of jurisdiction of the court where the wife has filed the case.
What else would you like to add?
I may like to add that interim relief, like stay of the proceedings in the court in which it has been instituted, can be sought. In cases of extreme indigence, interim maintenance can also be sought by the wife. Now, with the development of the hearing by video conferencing, the courts may progressively switch over to trial by that mode of trial. But this is a little futuristic. In which case, transfer petitions may, in course of time, phase out.
Thank you, sir. That was all. And in the next video, we will see in the criminal transfer petition. Thank you, sir, for joining.
Thank you very much.